Hi everyone, and welcome to our overview of Chapter 5, Search and Seizure. A reasonable expectation of privacy is a fundamental human right respected by all just governments. All persons have a fundamental human right to feel safe and secure in their own homes, to not have unwarranted intrusions on their bodies and personal belongings, and to enjoy personal, family, and associational privacy in their lives. Government officials should not be allowed to misuse the resources and powers they acquire from the people to spy on their own citizens, search them arbitrarily, or to seize persons or property without sufficient legal cause. In order to maintain necessary order and public safety, however, government officials sometimes do have a legitimate need to search a particular individual or seize something in the person's possession. School officials also face daily challenges to safety and order in their schools. How do public school officials continue to respect individual rights of privacy while also protecting the public school community from serious disruptions, drugs, weapons, and other unreasonable disturbances and dangers in schools? The legal principles defining this necessary balance between individual rights and legitimate community needs have roots that can be traced back thousands of years through Roman law and biblical principles. The Fourth Amendment's more direct historical antecedents, however, were the predictably abusive results of the general warrants for searches allowed under English rule in the American colonies. Laws enacted during the American colonial period allowed for general warrantless searches of the poor, searches of any person deemed suspicious, or other vaguely defined purposes. In practice, these policies set virtually no limits on official powers to arbitrarily search and seize persons and property. The abuses of these general warrants included, for example, government officials breaking into private homes at will, allegedly to enforce religious prohibitions. Government agents could kick in the door of a family home to be certain that no one was profaning the Sabbath with their loom or butter churn, that they weren't lying idle on other days of the week, or otherwise engaging in any act of debauchery such as drinking, gluttony, or any lustful or lewd behaviors in their own homes. Citizens had no legal rights to object to these unwarranted and unreasonable searches. It was at the time considered legally irrelevant that the searches were based on nothing more than suspicion in the air, the government agents' vague belief that somewhere someone must be doing something wrong, and that as an agent of the government it was his duty to find any of these wrongdoers wherever they may be, even those harming no one in the privacy of their own homes. Not surprisingly, such broad and unlimited grants of power were grossly abused by overzealous government officials, by those seeking to instill public fear of their official powers in order to gain obedient subservience from citizens, and by those motivated to harass particular individuals for personal reasons. These intrusive and oppressive practices helped to fuel the general rebellion against English rule that resulted in the American Revolution and in the creation of a new Constitution with a strong Bill of Rights limiting the power of government and protecting citizens' rights. The Fourth Amendment in that Bill of Rights was intended to protect against abuses of government power through unreasonable searches and seizures. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." As we discussed in chapters 3 and 4, individual freedom of belief is at the core of the First Amendment and the core of human liberty. Further, there is a core right to privacy in the human mind protected by the Fourth Amendment. Your personal thoughts and beliefs belong to you alone and are beyond the legitimate reach of government intrusions. Humans should enjoy complete freedom of individual thought and belief, free from government invasion and interference. And in the physical world, beyond the realm of pure thought, the right to bodily privacy must be vigorously protected by the Fourth Amendment. To have government agents exposing, touching, probing, or removing anything from a person's body without consent is obviously a severe intrusion on individual privacy, requiring a compelling justification from government. Although an intrusion on the home is not as directly personal as an intrusion on the body, it is nonetheless a very serious intrusion on individual privacy, Accordingly, the court continues to vigorously protect persons' privacy in their homes. Individuals' personal papers and effects are also protected under the Fourth Amendment. Today, these rights extend not just to paper letters and leather purses, but also to their electronic versions of persons' papers and effects. As the U.S. Supreme Court recently ruled in a unanimous opinion in Riley v. California, persons' cell phones cannot be lawfully searched without a warrant establishing just and efficient cause for the search. Whenever there is a reasonable expectation of privacy, the Fourth Amendment protects against unreasonable intrusions by government agents. Outside of that reasonable expectation of privacy, however, there is no Fourth Amendment protection. Individuals do not, for example, have any reasonable expectation of privacy in things they place in public view, leave unsupervised in public areas, or otherwise fail to maintain privacy or control over. The Fourth Amendment protects individuals' reasonable expectation of privacy in their persons, houses, papers, and effects, and requires government officials to establish that a challenged search was reasonable in its inception and scope. To conduct a permissible search, the government is generally required to establish probable cause to obtain a valid search warrant from a magistrate prior to any search under the Fourth Amendment. Probable cause is established by showing that the government agent seeking the warrant has knowledge of facts and circumstances based on reasonably trustworthy information in a quantum sufficient to warrant a reasonably prudent person to believe that a crime has been committed or property subject to seizure is present. There are exceptions to these general requirements, however, including searches incident to arrest, emergency situations, searches by consent, international border searches, and seizure of evidence in plain view. The court has also allowed lowered standards of reasonable suspicion rather than probable cause when special circumstances warrant a lower level of suspicion to justify a lawful search. In Chapter 5, we will address searches of students, strip searches, drug testing, locker searches, metal detectors and administrative searches, security cameras, electronic privacy, dog searches, police involvement in student searches, searches of school employees, searches of persons, and bailment of property. Chapter 5 will also introduce us to the essential judicial test governing search and seizure in schools, including the TLO test governing searches of students by school officials, the Redding test governing all strip searches of students, legal standards governing random drug testing, application of the plain view doctrine, rules governing administrative searches and dog searches, searches of employees, seizure of persons, and bailment of property. These legal standards can be used by school officials to assess the legality of their actions, work more effectively with legal counsel, and as a helpful guide in structuring and administering legally sound policies, making a working knowledge of these legal tests and their application in practice invaluable knowledge for all school officials. We must protect safety and order in schools, but we must also protect the reasonable expectation of privacy that all persons have, remembering that history clearly shows that allowing protections for personal privacy to be eroded opens the door to disturbing abuses of power and invites the emergence of a dangerous police state. There are few more certain warning signs of an emerging police state than a growing disregard by government officials of the privacy rights of their own citizens. A government under the just rule of law is essential to the protection of life, liberty, and property. But as our founders recognized in establishing constitutional limits on government, there is no greater danger to your life, liberty, and property than your own government officials gone rogue and acting above the law. The purpose of the Fourth Amendment and the Bill of Rights is to assure that this is not allowed to happen, that the smaller abuses of government power are ended before they are allowed to inevitably grow into bigger and far more dangerous abuses. In summary, when there is a reasonable expectation of privacy, the Fourth Amendment protects against unreasonable intrusions by government agents. Outside of that reasonable expectation of privacy, however, there is no Fourth Amendment protection. The Fourth Amendment protects individuals' reasonable expectation of privacy in their persons, houses, papers, and effects, and requires government officials to establish that a challenged search was reasonable in its inception and scope. To conduct a lawful search, the government is generally required to establish probable cause to obtain a valid warrant prior to any search. But the lower standard of reasonable suspicion is allowed when justified by special circumstances, as in TLO versus New Jersey. In TLO, the court held that because of the special context of public schools, the legal standard for school officials under the Fourth Amendment is reasonable suspicion. To be reasonable under the TLO test, the search must be 1. Justified in its inception. The school agent had reasonable grounds to believe that a search would produce evidence of wrongdoing, that is, illegal activity or a breach of school rules. And 2. Reasonably related in scope to the objectives of the search and not excessively intrusive in light of the age of the student, the sex of the student, and the nature of the infraction. Strip searches are generally disfavored by courts and require additional elements of proof beyond the TLO test. In Seizure v. Reading, the court held that a strip search of a public school student is only lawful if it satisfies the TLO test and there is 1. A reasonable suspicion of danger, and 2. A reasonable basis for believing that the danger is hidden in an intimate area. Generally, however, unless there is an emergency situation requiring immediate action, that is, an imminent danger and cause to believe that the danger is hidden in an intimate area, school officials should not be conducting strip searches of students. Regarding the plain view doctrine, under the plain view doctrine, there is no reasonable expectation of privacy in objects or conduct in plain public view. Contraband or illegal misconduct government officials can detect with the use of their common senses in public areas, including sight, hearing, smell, feeling of vibrations, etc., are outside of the protections of the Fourth Amendment. Regarding school-owned and controlled lockers and computers, there is generally no reasonable expectation of privacy in property owned and controlled by the school, including school lockers and computers. Regarding dog searches, when government-controlled search dogs smell the air in open public areas, such as school parking lots, hallways, locker areas, etc., the Fourth Amendment is unlikely to be applicable, as no search is involved. Simply smelling the air is permissible under the plain view doctrine. There are, however, Fourth Amendment limits to the use of search dogs in public schools. Fourth Amendment limits may be breached if the dogs are allowed to poke and jab their noses into students, come too close to students, students are asked to individually submit to very close smelling of the person by dogs, students are detained for an unreasonable time, or the dog search is otherwise administered in a way that is unreasonable, frightening, or embarrassing to students under the circumstances. Regarding the applicable legal standard for a lawful search, in TLO, the U.S. Supreme Court allowed a lower standard of reasonable suspicion governing searches of students in schools conducted by public school officials. For police officers, however, the higher standard of probable cause still generally applies, even when police are acting with school officials. Regarding administrative searches and metal detectors, searches of individuals generally require individualized suspicion and sufficient cause. Administrative searches, for example metal detectors, are an exception to this general rule. To qualify as an administrative search, the search must be aimed at a general danger, for example keeping weapons out of a public gathering area, and also be unobtrusive. Regarding privately owned electronic devices, the contents stored in students' personal electronic devices are electronic versions of their papers and effects under the Fourth Amendment. School officials may not search students' personal electronic devices if there is insufficient justification for doing so. They're going to have to meet the standards under TLO. Police officers should have probable cause, consistent with Riley v. California. Regarding searches of employees, public employees generally have a reasonable expectation of privacy in their office, desk, files, personal belongings, etc. They are protected from unreasonable searches by all government agents, including law enforcement agents and school supervisors. However, operational realities may reduce or remove any reasonable expectation of privacy in certain circumstances. Regarding seizure of students, Seizure of students should only occur when doing so is necessary to protect health, safety, or order in the school. Seized students must be supervised in a safe area, treated appropriately, and only detained for the time necessary. Regarding the bailment of seized property, school officials must use ordinary care in protecting any seized property from damage, loss, or theft, and they must provide students or parents with a fair process for redeeming items of value. In conclusion, the key to both compliance with the Fourth Amendment and protecting safety and order in schools is common sense in respecting people's privacy rights. Concerning student searches, always seek the most efficient and least intrusive means of achieving necessary discipline and safety objectives. For example, a search can often be avoided by simply asking the student to voluntarily hand over the object in question. Whenever possible, seek cooperation, not confrontation. Seek to resolve, not to escalate problems. If searches are necessary, avoid body contact whenever possible, especially any contact with private areas. An adult witness should be present, and the search should be conducted in a location that does not expose the searched person to unnecessary public embarrassment. If a coat or other exterior superfluous garment, a garment that's not essential clothing, must be searched, ask the student to remove the coat before searching it. Only go beyond exterior superfluous garments in an emergency. If the object sought is believed to be a dangerous weapon, make sure proper security precautions are in place before anyone approaches the student. Or if necessary, attempt to keep the student from endangering others by calmly steering the student toward a safer area until law enforcement officials can arrive. Concerning strip searches, generally do not engage in strip searches. Strip searches are disfavored under the law and should be avoided whenever possible. Strip searches of children are not only humiliating to the student searched, but they present grave professional dangers to school officials as well. If an intrusive search related to serious criminal conduct is warranted, but there's no immediate danger, make a police report and allow trained law enforcement officials to assume responsibility for any necessary search after the suspect is taken into police custody and away from school. If necessary, monitor the student until police arrive to prevent the disposal of evidence. If an intrusive search is necessary because of an immediate danger, assure compliance with TLO and the Reading tests and search no further than necessary. Never engage in an intrusive search for trivial items unrelated to serious dangers, for example, small amounts of money or candy. Neither judges nor community members are likely to accept strip searches of children over such trivial matters. Remember that your actions will be reviewed not only by a court of law, but also by the court of public opinion in your community. Concerning employee searches, retrieving files or other office necessities from a common work area in the absence of the employee because they are reasonably needed at the time generally does not constitute a search. If, however, the true purpose is seeking evidence against the employee was available to retrieve what was needed, or there is a reasonable expectation of privacy in the office area of the employee, Fourth Amendment protections should be respected. Chapter 5 on Search and Seizure addressed issues of privacy and necessary limits on government powers. These are issues of vital importance to us all. I am certain that you will find your readings in this chapter most interesting and enlightening. I hope you will enjoy your studies and that you will find what you learn very useful in your future. Very best wishes to all.